Welcome to everyone joining us. Today's session is slightly different to our normal sessions that we've held. Today we're talking about where does the fault lie, governance and corporate collapses. We have a panel with us this morning, and I'm going to ask all of them to please switch on their cameras and mics as well. As a quick introduction, we've got Ansie Ramalho. Ansie is part of our King committee. She's been the King 4 project lead. She's a Chartered Director South Africa and an experienced NED and also a previous IoDSA CEO. We've got Owen Skae, who is an independent panelist this morning. He's an academic, he's an associate professor and director at Rhodes Business School and has got a lot of experience and exposure in corporate governance as well. And then we have Juanita Vorster, who is our facilitator and audience representative for this morning. Juanita will go through with you now her role and how she will be playing the session. She will be managing the facilitation. Juanita is an international speaker. She's quite widely known for her facilitation skills in these type of setups, and she has her own marketing business that she's run since 2013. So without further ado, I'm going to hand over to Juanita, but before I go, I would just like to address the Q&A for this session. As I mentioned, it's a very different session this morning. It's more of a debate and a panel discussion versus a presentation like we would have normally done in our previous webinars. There is no Q&A session at the end, but questions will be answered and addressed by Juanita throughout the session. So please put your questions in the Q&A box throughout the discussion. Juanita will explain how her role is going to work, but she will be looking at the questions that are coming through and she will work in those questions into her facilitation to our two panelists, Owen and Ansie. So please put in your questions here throughout and don't wait for the end. So with that, Juanita, I'm going to hand over to you and I will see you all again at the end.
Thank you very much. Good morning, everybody. So my role today is to play a neutral, independent facilitator and to ask the questions that seem to be popping up a lot in King 4 conversations and to put them to Ansie and Owen and to facilitate a discussion in a conversational way, not to get to a point where we are just talking about King 4 and corporate failures and so on, but where we are looking at it from a deeper and a wider perspective so that we can explore all of the things that should be said, that the general public seems to want answers to. That is my role. So I would really appreciate it if you could help me fulfill that role, please, by posting your questions in the Q&A section. As they pop up in your head, ask them. Ansie and Owen have assured me that they are ready for anything this morning. So please do ask those questions. We do have two informed experts available at this morning for an hour and a half, and I think we can get to a few sticky issues. So today is not to choose sides necessarily, but it's definitely to get into those sticky issues so that we can have a conversation, because having those tricky, sticky discussions is the only way we as directors, we as people, we as companies, we as boards, and we as an economy and a country can grow. So when I was preparing for the session, you know, reports of the past few weeks and judgments filed and applications made by shareholder groups, it seems like shareholders seems to be on the losing side of corporate failure. It seems like they are the only ones that are on the losing side of corporate failure. Recently, the courts dismissed cases made by shareholders of Steinhoff and African Bank, where the shareholders decided to take matters into their own hands and saying, well, we lost something and we want to get that value back. It is our right. We lost. Someone needs to give it back to us. And those cases were dismissed. So if we then look at corporate governance as a whole, and we say that corporate governance is the way you guide and the way you direct companies, and the people doing that is called directors. And these directors are expected to give or to have good behavior, to act in a way that's the fiduciary duties, that is ethical, etc. It seems that bad behavior, if we can group it, that bad behavior is the cause of all corporate failures, whether it's misstating financial statements, whether it's unethical conduct, whether it's nepotism, whatever it is, bad behavior causes it. But there are things in place to prevent this bad behavior. Leadership courses and business books and King 4 that says if you want to do a good job, here's how you do a good job. And the Companies Act and the Constitution. We have all of these laws, we have all of these books, we have all of these everything. So there's enough to prevent it, but it seems like it's not enough. What I'm picking up also is that there's a general feeling that the prevention, the preventative measures, they're not enforced. And that when the prevention that is not enforced, when the prevention then fails, it seems to be up in the air. There seems to be no cure. So with that in mind, the cause, the prevention, and the cure for corporate failures, I'd like to post the poll to you now, Vix, if you can assist me with that, please. In your view, with these corporate governance failures, not Ansie and Owen for now, this is a poll to the audience, where does the fault lie? And it's a multiple choice, so you can choose as many as you want. Keep the polls running. There are more options down to the bottom of the block. If you scroll down a little bit, don't miss out on them. I'm going to give quite a bit of time so we can start seeing. Remember, this is supposed to be a tricky and a sticky conversation. So it's great that we can see your input as well. Remember, if you have questions that you would like me to pose to Ansie and Owen, to please post them in the Q&A function, not in the chat function. Going to give 10 more seconds until we close the poll. 9, 8, 7, 6, 5, 4, 3, 2, 1. Right, and that is the end of the poll. Let me share the results with you. So the majority of the audience today says the fault for corporate failures lie with the board directors, 74%. 1% says King 4, 4% the Companies Act, 15% shareholders, 67% the CEO and executive management. And I've got that correct. That is our second highest. Yes. So first, board and directors, then CEO and executive management, then the auditors, then the regulator or the lack of a regulator, then application implementation of the Companies Act in King 4. And it seems like corporate governance, industry, trainers, advisors, etc., they carry 13% of the blame. Right, so that is a nice basis for this discussion. We're going to run this poll again at the end of the session to see if we have been able to touch on a few other insights that is broadening our understanding and can help us to be better directors, build better businesses, and build a better South African economy. So, Ansie and Owen, here we go. The first question. King 4 is part of the JSE listing requirements. It seems, however, if we look at all of the media reports, that King 4 is part of the listing requirements, only seems to keep companies out rather than picking off the bad apples. So if you're not compliant, then you can't come into the JSE listing fold. But if you're in, it's okay, you can stay, is what it seems to be saying. If King is then the prevention of corporate failures, and the Companies Act is supposed to be used for a cure when things have gone wrong, but it seems to be a cure that only protects the bad apples, where can shareholders go to get their money back?
So, Juanita, would you like me to start?
Any which one, okay. You can raise your hand.
Okay, thanks. Right, so good morning everybody from Makanda. So, look, it's a very complex question, and I think one can understand the tremendous anger that people feel when companies fail, particularly where there's been malfeasance. But there are remedies, and if one looks to the Companies Act, Section 19 clearly states that the company is a juristic person. Section 20 around the validity of corporate action, piercing of the corporate veil. Section 72, the board committees. Section 76, it's the law that says that the board is accountable to the company, and you have a legal obligation to act in the best interest of the company. So very often you hear people saying that the board is accountable to the shareholders. That's not correct. And that's not King 4. That's the law. So the King Committee and the King Code provides a framework, a set of recommendations that suggest you apply and explain on that basis. Section 77 is related to how you may be held accountable for the things that you do. Section 158, remedies. Section 159, whistleblowers. And if one looks at the case of African Bank, where Section 218, they tried to bring a civil action, the court dismissed that. And so the purpose of the article that I wrote was really not to in any way suggest that directors have less of a responsibility to shareholders. The article was designed to say we actually have greater responsibility because of these problems that may be encountered when there's corporate misdemeanors. And therefore, we need to better understand the landscape in which we're operating. So as a shareholder, you're going to take a risk. There's this thing called limited liability, and there's very good reasons for that. That means that you stand at the back of the queue. So obviously you need to inform yourself about the company that you are planning to buy shares in. Ultimately, when you get onto the board, yes, you indicate that it's a mandatory requirement. Again, that's not the King Committee that says it must be a mandatory requirement. That's the listing requirement of the JSE and their regulations in relation to that. And I'll stop shortly, but just before we came on to this webinar, I was just going through my notes. Steinhoff, for example, in the early days, did not have a social and ethics committee. And the only two committees that are mentioned in the Companies Act are the Audit Committee and the Social and Ethics Committee. So why didn't Steinhoff have a Social and Ethics Committee? These are the kinds of things that we need to inform ourselves on and get the requisite answers to. I'll stop there.
Ansie, your response, if you want to be, before I counter Owen's answer.
Thanks, Juanita. Yes, I want to link to what Owen has said, and that I strongly feel that we have to arm ourselves with knowledge. There's a few things that are percolating here, and I think we are confusing various aspects. Firstly, I think we are talking about King 4, and then we're not very clear about whether we talk about King 4 as the guidance and the standards that are set out there, or whether we are talking about the implementation and the application of King 4. Those two things are very different things. Then we are also talking about King 4 and what King 4 says as second-hand knowledge. I often look at articles that cover King 4. I often look at responses given at AGMs to questions raised by shareholders, and then King 4 is quoted as the authority or the sanction for the company's behavior. And then I don't see that that question is followed up with the challenge to say, no, hang on. If you say that time is not a factor in independence of directors, and so therefore as shareholders you don't have to worry, what utter rubbish. King 4 does not say that. It's as if none of us want to go to the trouble, directors, shareholders, media, all included, to read King 4 ourselves, to have first-hand knowledge, but we all have opinions on it. So I really think we must be careful in how we use terminology, how we interpret King 4, make sure that we do it of a solid basis. So knowledge for me, number one, and it starts with the directors. Having said that, I also want to acknowledge, listen, our governance system is not perfect. King 4 is not perfect. Our Companies Act is not perfect. Our directors are certainly not perfect. So I'm not defending and saying that there may not be areas for improvement. I think we must all be open to learn together and to understand what we can improve. But let's do that from a basis of knowledge.
Thanks very much, Ansie. What I'm hearing you both saying is that prevention is still the best cure, and this prevention is knowledge of the Companies Act, knowledge of King 4, knowledge what the difference is between the theory and the application and the various parties in the application and so on. For me, it's still what Owen said. So the shareholders carry most of the risk, all of the risk, it seems like. So we can say have the knowledge across the board, understand the landscape, etc. It still does not talk to what are all of these systems, all of these structures, all of this knowledge. If we then go the knowledge route, what does that help when things have gone wrong? Who is the watchdog? Who enforces this kicking out of the bad apples?
Juanita, so the stakeholders are the watchdog. You know, so the King Committee will say that the stakeholders are the ultimate compliance officer.
Oh,
and we
sorry,
have seen instances. Stakeholders. They are the ultimate compliance officer, right? So the point is that the board is accountable to the company and through the company to the shareholders, because the shareholders can come to the AGM, they can vote out the directors. It's not to say that shareholders are powerless here. Shareholders exercise a fair degree of power in relation to voting in or voting out directors. Shareholders can come to AGMs. Now, regarding remuneration, that's a non-binding advisory vote. And I think we also need to understand how the focus of King has changed. Under King 3, the definition of governance was still directing and controlling. It was an instrumentalist approach. King 4, the definition is ethical and effective leadership with the achievement of 4 mindful outcomes. Now, those mindful outcomes are an ethical culture, good performance, effective control, and legitimacy. The legitimacy is what talks about the stakeholders being the ultimate compliance officer. Now, if we talk about Oak Bay seems to be a company that's never really spoken about. You know, we hear about Steinhoff, we hear about Tongaat Hewlett. It's almost as if the assumption is that the Guptas, because they seem to be so corrupt, that let's not talk about Oak Bay. Oak Bay was completely innocent in terms of the company. The focus of Oak Bay was to be used as an instrument of self-interest. But Oak Bay is no longer operating. Why is that? Because the stakeholders withdrew the license to operate. Now, people say that the bank should have acted a lot faster because ultimately they couldn't have a bank account anymore. So we see a very clear evidence there that where there was malfeasance, that society responded in a particular way. Now, in relation to Steinhoff and Tongaat, these are much more complex. And in the article, I made the point that notwithstanding the fact that the previous directors of Tongaat had put in there that they ethical and all of those things, and we can call that greenwashing. You can say the same argument. There's the Public Finance Management Act, there's the Municipal Finance Management Act, there's POCA. If you are found guilty of racketeering, you can go to jail for life and you can be fined R1 billion. If you are found guilty of anti-money laundering, you can go to jail for 30 years and be fined R500 million. That doesn't stop people from doing money laundering. There's plenty of evidence of racketeering in South Africa. But what that court case demonstrated there is that the shareholders stand at the back of the queue because there's very good legal principles. We can't just open this up. If you take section 165, which is to do with derivative action, there is recourse for you to come, but it's the court that decides, because you want to avoid a situation that every aggrieved shareholder, any aggrieved person can come and bring action. It would paralyze companies. They would never be able to get on and do what they're doing. So the King Committee says, apply these mindful outcomes. And we need to make sure that you've got people with integrity, competence, they're prepared to be responsible, accountable, fair and transparent. Let's get them onto the boards. Then we need to interrogate our business model, and we're looking for sustainable value over the long term. The profit maximization maxim itself contributes to this focus on let's get shareholder returns. It's going to put us on the path of distraction. You may be the most profitable company for the next 10 years, but with climate change, in 15 years' time, there's no more company. Effective control. We need to have proper lines of defense. And I see today, so let's talk about Wirecard quickly, the German company. What happened there is that, in fact, when they started to do the short selling, the regulator stepped in and banned the short selling. Today, I see the chairman, the global chair of EY has shown regret and remorse for the fact that EY did not uncover the fraud. And Tongaat Hewlett, there's a case where there was a financial analyst at Investec called Anthony Geard, who shone the spotlight on the poor financial performance of Tongaat Hewlett. And guess what? He got wrapped over the knuckles, and Investec Bank issued an apology to Peter Stardy, then the CEO, to say, you know, that's not the view of Investec Bank. Mm. Now, if you've got a bank that's apologizing, wrapping an analyst over the knuckles, if you've got auditors who subsequently express regret, you've got regulators saying that you can't short sell, a self-regulatory code of governance is never going to change the behavior of those directors who have malintent in the first place. But what we need to do is we need to bring those directors to account. And there are remedies to do that. And perhaps we need to find better ways to make sure that that happens a lot quicker.
Owen, I want to hear more from you when you say we should, who this we is. But Ansie, over to you quickly. There are a few comments, a few questions in the Q&A section. Reminder, ladies and gentlemen, to please post your questions not in the comment function, but in the Q&A function. Ansie, can you please describe for us, or just clarify for us quickly, what is the role of the Companies Act? What is the role of King 4 in terms of law, regulator, who oversees this? When we say a we or a they, specific name of who the regulator is, who can take directors to account and so on. If you can just paint that picture for us, please.
Right. So the Companies Act is the Companies Act. That is, it's the law. Our jurisprudence is part of that law, and there's nothing that the King Committee or that apart from perhaps an advocating role, which we have fulfilled in the past, which led to changes in the Companies Act. But ultimately, when we draft a King Code, we have to stick within the boundaries of the Companies Act. We are bound by it. Our Companies Act, just by the way, is based on our common law heritage in the main, which we share with countries like the UK and with Australia and New Zealand and the United States. So it's the mechanisms that Owen has explained for enforcing shareholder interests is not peculiar to South Africa. It's very much in line with our common law heritage, and there are very solid reasons for why the Companies Act reads the way it does. Having said that, I also appreciate that there is sometimes frustration with it leading to what is experienced as unfair consequences. And we can have a whole debate about that. Having said that, we are bound the King Committee is bound by the provisions of our Companies Act and by our court's pronouncements. So what King 4 then does is King 4 or any code of corporate governance, it gives content to the legal duties of directors. So one way that you can look at it is that the Companies Act, the MFMA, the PFMA provides the bones for directors' duties. And then King 4 puts the flesh on the bones. It just assists directors with understanding how they should execute those legal duties. And it's for this reason that the courts are referring now to our codes of corporate governance when the court has to interpret whether the due standard of care, skill, and diligence has been exercised by a director, because King 4 has become the benchmark for providing that provision with content. Now, having these rules in place is just a starting point. If you think about it, King 4, the Companies Act, is really words on a piece of paper or on a website. What has to follow it for a proper governance system is that these rules, standards, guidance must be interpreted and implemented. And part of interpretation and implementation is a certain mindset. So you could have a compliance mindset. In other words, I will do just what is absolutely necessary. You can have a tick box mindset, and you can say, well, I'm just going to tick the boxes. Or you can say, let's follow the spirit of King 4. And King 4 is outcomes-based, as Owen has also pointed to. Our stance in King 4 is that you can never say that you have good governance just by virtue of the fact that you can tick the boxes. Ticking the boxes is the input. What about the output and the outcomes? So even if you can tick all of the boxes, you can say, I have an audit committee. My audit committee is comprised of 3 independent members. We have a terms of reference for our audit committee. Tick, 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 tick. Even if you can do all of that, that does not mean that you have good governance in place. For good governance to be in place, you have to assess it in terms of outcomes and outputs. If your audit committee is not effective, if under its oversight, you have accounting irregularities, as it's politely put, then how can you claim that you've had good governance in place? Sure, good governance is not is not a guarantee against these sorts of things happening, but they, as you said it earlier, Juanita, it's a preventative measure. It optimizes your chances for this sort of thing not happening. So if we look at corporate governance from an input point of view, from a box ticking point of view, we're missing the mark. King 4 is very, very clear that it's not about ticking the boxes. It's about assessing what the output and the outcomes are. And here again, I want to agree with Owen to say, this is the job for this system to work. And it is truly a system. It's a whole ecosystem. In your poll question that you put up at the beginning, all of the role players in that ecosystem were mentioned. All of those role players must play their role. The management must play its role. The directors need to play their role. Institutional investors have a critically important role, and it's ironic that we see the individual shareholder activists being more active in this space than our institutional investors. It's about civil society. It's about the auditors. It's the whole collection. All of these role players must play their part.
Thank you, Ansie. It seems to me then that we are stuck between a rock and a rotten place. So if we've got the Companies Act, and if we've got King 4, and if we are saying we understand it's all preventative and all preventative, and if we fill it with an ecosystem full of players that don't want to, then, oh, sorry, that's it. But there are other countries that score higher on the Transparency International list that don't have corporate governance codes that are lauded the world over. They score higher than South Africa. So the rock and the rotten place. Is that then it for South Africa? Is this what we've got to deal with? Is what we're saying, if you invest in South Africa, you carry all of the risk and you've got to suck it up?
You don't, definitely not. Excuse me. You know, I think that we shouldn't allow a few bad apples to but unfortunately what we see is that when you have bribery and corruption, it's like a virus. It spreads through and it breaks down the system. Now, Dan Ariely, the very famous behavioral economist in the US, he makes the point that if you take the human beings, that 1% of us are basically absolutely virtuous in the way that we view the world, incorruptible. There's 1% of people who are absolutely fully corruptible, almost evil. And the rest of us fall in between. There's 98% of us. So I guess that's you and I, because I can't claim to be the 1%, and I certainly don't believe that I'm on the left-hand side of the 1%. But I appreciate that I myself am in positions of governance. And this is where we need to have checks and balances and separation of responsibility. We need to stay in our lane. So if you cross that line, so the board, it's management that's the first line of defense. It's the auditors that are the third, and there are, some people talk about more lines of defense now. Internal audit, and the fact that the chief audit executive reports to the chair of the audit committee, that you don't have a CEO and the chair of the board sitting as members of the audit committee, for example. Steiner, for example, the audit and risk committee was combined. King says that's okay, but if you can't do the work of audit and risk separately, you need to separate them. So we go and we look to the King Code to assist us. But ultimately, you can apply and explain. Now let's take the SPA Group, for example now. SPA Group have announced their next chair, who happens to be the current CEO of the company. Do I stand to be corrected there? The King Committee says that you need to have a cooling off period between the time that you are the CEO. Now, presumably, the board of SPA has applied its mind, and it will have to explain, because I'm assuming that people come and ask questions. Why is it that the current CEO is going to become the chair of the SPA Group? And this is contrary to the recommendation that's in the King Code. Now, I believe that our understanding of the King Code is sensitizing us to the kinds of questions that need to be asked. There's a very famous case, again, in South Africa, the Minister of Water Affairs. So I need to just look at my notes here, and Forestry versus Stilfontein. Now, interestingly enough there, the directors in that company were surnamed Kebbel. What happened there was that the directors resigned en masse, all at once, every single one. And the judge was absolutely flabbergasted. He said he trawled the entire world. He did not find a case anywhere where all directors had resigned all at once. And he went to the King Code to try to seek an answer there. And if you read it very clearly, he says that the assumption was that they resigned in order to avoid any problem that was going to come to them later on. If we talk about negligence, gross recklessness, and so on. And he was very, very unhappy with their behavior. At the end, there was a fine of 15,000 Rand that was levied. Now, of course, this is ridiculous that you have directors that can behave like that. But my understanding of that whole thing is that those directors never had any intention in the first place of reading what the King Code said, and to apply and explain the kinds of things that need to be done. So we need to make sure, again, I'm saying, integrity. I believe too that it's about being proactive. I'm not against shareholder activism, but in my view, those shareholder activists that come to AGMs and say, we are unhappy that you didn't give us a 30% return, you only gave us a 25% return, you haven't paid the dividend. Those are yesterday's shareholders activists. The shareholder activists of today are the ones that are coming and saying, what are you doing about climate change? How are you embracing integrated thinking in the boardroom table? How are we dealing with social inequality in South Africa? Because we want to be a responsible corporate citizen. And a friend of mine was telling me the other day that he sat in a presentation by a well-known fund management company. And that fund manager made the point that the younger investors of today are not investing in the fossil fuel companies anymore. They're specifically saying, we do not want our money to go there. We want our money to go into the ethical companies, because I'm thinking already about my future and my children. Now, this is where King 4 says we have to apply these mindful outcomes. So if the language that comes out of the board of directors is contrary to ethical culture, good performance, effective control, and legitimacy, then as shareholders, we should withdraw our money. We should sell the shares that we own. And as Ansie says, you know, there are many checks and balances, but the King Committee cannot make the law. Yes, it will come into common law, and it's happening. It's the judges that do that. And the judges themselves have said, that case that I referred to earlier about, sorry, I didn't, but Investec Bank was sued about the definition of what a member is. And what was interesting about, they tried to draw on section 252 of the previous Companies Act. And what the judge said there was that if your name does not appear on the register, you can't bring action. So in other words, if you're in a pension or a provident fund, or you have nominees, there's no recourse to you, because what you could have done is you could have opted out of that and bought your shares directly. I think that directors need to read these seminal cases. They need to understand what the law says about these things, so that when we sit around the boardroom table, there's a sense of gravitas, of the responsibility of the decisions that we make, because the consequences for shareholders, creditors, employees can be absolutely, so catastrophic that people can lose their life savings. You could end up in a company that in 10 years' time has no water. So these are the kinds of things that boards need to apply their minds to today. And King 4 is not perfect, but it's saying we think you need to try to do this on an apply and explain basis.
I think, Juanita, if I may, thank you, that we need to elevate the discussion. We're talking about mechanical processes and structures and procedures, and we're not lifting ourselves out of the detail of all of this. Which is another way to see, just to say we're not thinking, we're thinking about input and not outputs and outcomes. So when shareholders challenge, I agree that we need to start challenging on these high level issues. When what I would say is concerning for me is the way that it seems that companies are responding to the challenges that are raised by investors. They appear to be dismissive and try and get rid of the question as soon as they, or as easily as they can, and often King 4 is used as the reference point to just dismiss the question. King 4 allows this, so therefore we can do it. Instead of lifting ourselves out of those mechanics and saying, okay, yes, but bigger picture. What does that mean for the company? What does that mean in the long term? What does that mean for stakeholders? So if you say that your remuneration policy is this and that, let's get ourselves out of the mechanics of it. You know, King 4 says, yes, it's allowed and not allowed. No, King 4's overarching approach is integrated thinking, sustainable development, the outcomes that Owen has mentioned. Are we achieving all of that? The principle in King 4 on remuneration says fair, responsible and transparent remuneration. Are we true to those principles? Are the mechanical issues, the structures, the process, the policies leading to fair, responsible and transparent remuneration? If not, you've not done what King 4 says. So we get stuck in the detail instead of having that bird's eye view, long term, integrated thinking. That's, I think, how we should look at corporate governance.
So if we do then move away from the mechanics and the things and the bits and the bobs that can be manipulated and can be done in corporate governance, let's then focus on the who. Owen, and it comes back to an earlier point that you made, where shareholders can vote directors out. But there's a few steps in the process of appointing a director. And of course, it's made even more complex by private companies, which are for-profit and not-for-profit, and then public sector companies as well. So it starts with the appointment process, right? That is often done, and this is, please check my understanding, that is done by the nominations committee. So if the nomination committee recruits, they only get a handful of directors in according to the list of requirements they put out, you know, and then we take it one step back. What should be on that list of requirements? Because if the list of requirements says you need to know finances, you need to know this industry, you need to have served on a board, that seems logical, but it seems to not be working. So what should change from a list of requirements point of view, including to the point of psychometric testing, which is one of the questions in our Q&A, and professional designations and competency certificates, one of the other questions in the Q&A. What should that list of requirements look like? Should the nominations committee just be tied to deadlines because of rotation periods coming up and terms being served? Should that be pushed through? Should the shareholders and the other stakeholders only have a small selection of directors to choose from? Who does the appointments in public and in private sector? Your comments on that. And then, you know, we might have all of the best directors, whether on a public, private, for-profit, not-for-profit, and they might have done all of the site tests, etc., etc. And then they fed bad information. So let's look at the players, the closest players in terms of the directors, how they're appointed, how they're brought in, and the information they've got to deal with, and the accountability and responsibility of the CEO and management before we even get to the auditors, regulators, and all of the other parties that play an assurance role. Big question. Who's first?
So I think, Juanita, that you know, how nominations committee function is a result of the tone set by the board and the vigor of the challenge by shareholders. The board of directors is the focal point of governance. There's no question about it. And sadly, I also think that directors are often a weak link currently in the South African landscape. And I'm generalizing, and there are, of course, many exceptions, but let's look at Steinhoff just as a case in point. So I'm asking myself questions, and I don't know all the detail around it, and I don't know that it's public knowledge, not as far as I know. But what was the thinking around appointing one of the board members' sons to the board? Did he have particular qualities that were really necessary for the work done at Steinhoff? Why was this person's son appointed? And then another director's daughter succeeded him when he stepped off the board. I mean, doesn't that smack of you know, positions for people we know and who are family and so on? I don't know what it is. I'm asking the question. Where's the transparency around that appointment process? The directors who served for such long periods, where was the transparency around that, apart from just saying, and I looked at the Steinhoff reports, just saying that these directors' independence were assessed, and then after serving 15 or 20 years, they were still regarded as being independent, but without giving any reasons, any rationale, any substance to that statement.
I'm going to interrupt you quickly. If you say, where were those things? Where were those reports? Who was responsible for giving those reports? Because shareholders have once a year AGM, and they are being fed a pretty presentation and a pretty integrated report with no, you know, that don't necessarily allude to those questions. And the average investor don't necessarily know all of these things, which brings back to your point of we should equip ourselves with knowledge. But if you then say, where was that? Who was the person, the entity, the responsible party that should have disclosed that? Where was it?
Where were the institutional investors? Because they are supposed to equip themselves with this knowledge. In asking the questions about a son joining his father on the board, a daughter succeeding her father to replace, where were the questions? You know, style of the same as the other instance that Owen referred to. Also, the analysts, there were analysts questioning long before things had gone wrong, questioning some of the accounting practices at Steinhoff. And again, this person was so embarrassed and bullied, and the bank that he was, the investment bankers that he was part of, actually distanced themselves from this report because they were making a lot of money from the deals that happened on the other side of the wall of that institution. So you can see where I'm coming from when I'm saying it's a system of checks and balances, and that there should be accountability. Boards should not be left to do what they want to do. There should be questioning and there should be challenge on that. And when boards start using King 4 to say King 4 allows that, King 4 King 4 is not a set of rules that you follow slavishly. You know, just on to get back on the independence. If you look at directors' independence, King 4 says, let's look at a CEO who steps down as CEO, or an executive who steps down as an executive and then joins the board. If you look at that situation, King 4 says the soonest that this person can be regarded as independent is after 3 years has expired. And then many companies latch onto this point and they say, oh, well, King says after 3 years, this executive may be classified as independent. But then we forget to read the bit at the top of these independence indicators, and which says that these indicators should be used substance over form. It should not be used as a formula. The board should apply its mind to this, and it's a responsibility of the board to explain and to have a reasonable basis for justifying whether a person is a director is independent or not. So in other words, you can't just take that little bit that says after 3 years the person can be regarded as independent. That's just a minimal requirement and indication. There are lots of factors that go into it. So let's say management has not changed at all within those 3 years, right? That that the person who used to be on the executive and now sitting as a non-executive, that the colleagues that he worked with in an executive capacity are all the same people. I'm not then sure that 3 years is enough of a cooling off period. But let's say that out of the 5 executives, there are now 3 that have moved on, or you know, people have been brought in from the outside to serve on the executive. Then there's perhaps more of a case to substantiate that that person can be regarded as independent. Again, let's understand what it means to apply our minds and not think in a rules-based manner.
We're getting into the technicalities again, though, of King and what should be done and independence and what defines independence. I'm still after this question of the who bit. How do you determine, how can NOMCO determine whether a director is fit to serve, whether they do have integrity, whether they do subscribe on ethical behavior? So it's not just skills and competencies based, but also behavior based and intent based. Tone set at the top, etc., you know, when we vote them out and so on. I'm after the question of who because the what is done, the what is there in the Companies Act, the what is there in King Crows as being used as common law, etc. The prevention is there. It seems like this rock and rotten place is all dependent on the who, and that we're getting it wrong. Owen.
So Juanita, we have to be practical too. I mean, we don't have a general election for boards of companies. I mean, imagine the practicality of that. It's not about a popular vote. It's not about opening it up to the entire society and saying, that's not practical. We also have to acknowledge that the word accountability, what does that actually mean? I often find when I facilitate, ask people that are actually directors, what does accountability mean? They struggle to articulate what it means. If you want a definition of accountability, go and look in the King Code. You're not going to find it in the Companies Act. It's used there, but you're going to find the definition of that. And it says you can't delegate accountability away. Now, we also need to acknowledge, and often there's this call, my understanding, and I'm not part of the, I'm not part of the King Committee. So as Vikesh introduced me as an independent person, but so this is my interpretation. So I think that King 4 came under criticism because people were saying that you needed to take a harder line on remuneration. This non-binding advisory vote. Now, the Bratton article that I referred to when I wrote that for article that was published in Moneyweb. So, and that was the Enron case. Now, Bratton wrote there about the compensation of executives, which I didn't really allude to, but it's indirectly referred to in the profit maximization. Now, when you worked at Enron, it was made very clear that every day you're there for the shareholder to maximize profits. And in fact, what happened is that when some staff members did things that were technically wrong, as long as it achieved the objective of these super duper returns, they were seen to be the heroes or the champions. So it's what Ansie spoke about, the tone at the top. It's set by the board, and the board cannot delegate this away. So it's the board that is accountable and responsible for how the nominations committee conducts its work. Now, the King Committee says that you need to have a diverse mix of skills and knowledge, and King 3 was more prescriptive around what defined independence. And I think what happens is that often these things take root and they kind of become urban legend, and then they carry on. But the King Committee has never taken a compliance approach. It did once upon a time, because under King 2, it was comply or explain. The US is a rules-based system. In the US, it's comply or else. Now, what does the tone of comply or else sound like? Imagine that you've got now, maybe in South Africa, there's a call for comply or else. In other words, comply or else, and I'm wagging my finger at you, Anita, comply or else I'm going to come and get you. In King 3, it was comply or explain. And what was happening there is that companies were explaining what they weren't doing and not explaining what they did. So then we said, okay, look, not me. I'm just saying it as the collective. You asked me before what I meant by we, but I guess the point was, we don't want you explain to us what you're not doing. We want you to explain what you are doing. And that comes back to the mindful outcomes. So as Ansie says, and yes, it is a little bit of the detail, but it's the board. Why do we have non-executive directors? Why do we have independent non-executive directors? And I was interested again that the comment that Koos Becker made about remuneration of non-execs. I don't know exactly what he was referring to there, but he made a comparison to Amazon. Now, if you're a director of Amazon, then you have to actually own shares in Amazon equivalent to 3 times your annual remuneration. Now, somehow it's got into the folklore that the King Committee says that if you're a non-exec, you can't own shares in the company. That's not correct.
Yeah.
What the King Committee says, it doesn't say it straight out, but you have to put your own money in there. You have to put your hand in your pocket and put your money in, because you want to have skin in the game. But what we saw with Steinhoff is that the chair of Steinhoff, Christo Wiese, the amount of skin he had in the game ran into billions. It didn't prevent somebody that he trusted so implicitly in Marcus Jooste. And what happened is that when Parliament called the directors to come and explain, they all said, oh no, we were blindsided, we didn't know what was going on. And they play the victimhood. It's always somebody else. And when you go and ask the CEO, you know, what about the CEO? He said, oh, no, it was somebody else. It was the auditors. It was everybody else. It was never me, because we're not prepared to be accountable. So we talk about psychometric testing. There's a lot of literature around how is it that toxic people who trample over other people end up being CEOs? How is it that narcissists end up being CEOs? But in my view, those days are gone. These are very dangerous people. And so you need to have board members who understand that the human condition is complex, but it doesn't mean that we must all think that everybody's bad. We need to put the checks and balances that I've spoken. So if your CEO is somebody who always insists on flying first class, wants to have a penthouse overlooking Camps Bay, wants to specifically buy a company because that gives him the best view to look at a racehorse event, that's not your CEO. One of my MBA students did a fantastic study. He looked at again, we're finding more and more that even at business schools, we're researching more around King 4, and hopefully this is going to come more. But essentially what he showed, an archetypal analysis, that there have been CEOs in South Africa who have forgone bonuses because the company hasn't performed. And what he did was he went and looked at the leadership characteristics of those CEOs. And what you find is that they're the humble ones. No, those are the ones that are really committed to doing what's best for the company. And they understand. Even though they may have worked 5 times harder than they worked in the good times, they don't, for them, money is the secondary thing. It's not what drives them. And so this is where the board has to develop the emotional intelligence. Lastly, I want to say, I came across a very interesting research project that was done and in the US, which looked at independence. And what they found is that the degree of independence of directors didn't necessarily make the company a better performer than another one. So, but it's international best practice now. Even in the US, the majority of boards need to be people that are non-exec status, although the chair and the CEO can be the same person. Although we saw Elon Musk, he's no longer the chair because of his tweeting policy. So even in the US, they're prepared to make that distinction now. But what they did find is that where there was strong independence, the CEO got fired faster than would have been the case. Now, what happens then? Fire the CEO, you find the performance of the company, the new CEO comes in, there's an increase in performance. But for us to understand these correlations are very difficult, cause and effect. So that's where you need to have board members of wisdom, diversity, experience that understand all of these things. And they get paid a lot of money to do this, even if you are an independent non-executive director. So we need to hold them to account through the questions that Ansie's talking about. I don't think we can lay it solely at the door of the institutional investor, but they've got the kind of analytical ability to do the things that need to be done. And Anthony Gerd is an example. Let me stop there.
It seems just quickly, I want you to wrap my next question to this. It seems like I struck a bit of a nerve with our audience as well, because the Q&A section is kind of blown up a little bit. It seems that there is huge frustration, not with the lack of boxes to tick, not with the lack of frameworks, not with the lack of things that people should be doing, but with the people that are not doing the things. Questions ranging from BE appointments to minister appointments to cronyism, to nepotism, to bullyism. All of the isms you can possibly think about are listed in the Q&A section. So it seems that we have to delve into this people thing. How do we then get those people that Owen referred to, those that want to do the right thing, those that understand leadership, that understands human nature, etc., etc. Where do nominations committees find them? And can we lay the blame for all of these corporate failures? Because the title of the session is, where does the fault lie? Does the fault lie with nominations committees and nominations processes? Or, devil's advocate, rock in a bush, is it a lack of suitably experienced, qualified directors that can also behave in an ethical manner? Once again, big question. Ansie, I interrupted you, so both questions to you.
Juanita, I get back to my earlier point. I think we're looking for easy answers. quick answers. And there are no easy and quick answers. We need to reflect on this. We need to be deliberate and understanding how all of the pieces of the puzzle fit together. We've spoken about corporate governance. Governance is an ecosystem in terms of all of the role players. I want to now speak about corporate governance as you know, all of the ingredients that go into it. And King 4, and I'll bring it back to your question about the nominations committee. So King 4 is part of the ingredient. The company law is part of the ingredient, but it's only one part of it. It's not the full, it's not everything that goes into baking this corporate governance cake. King 4 and Companies Act and those sorts of things is just one thing. Owen referred to culture. Culture is another ingredient that goes into corporate governance. Culture, just the things that we do habitually, the patterns of behavior, even our unconscious behavior, our unconscious belief system, which binds us. Culture is a very important ingredient to corporate governance. Owen's referred to the fact that 2% of us are, according to Dan Ariely, he's a behavioral economist, that it's only a very few of us that are almost always ethical or almost always unethical. The vast majority are influenced by the situation. So we kind of sit on the fence, and then we are being informed by what is going on around us. And you can then see how culture fits into that picture. If you're sitting on the fence and the culture around you is unethical, chances are good that you'll also lapse into that unethical mindset. And the other way around, if the culture is ethical. And unfortunately, we all know where we are today is that we, in terms of our country, probably live in a culture which is, if not downright unethical, it's really on the verge of it. So it's the rules that go into it, it's culture that go into it, but then it's personal belief systems, and it's of course those personal belief systems, those individual belief systems that eventually culminate in the culture. And then your belief system manifests itself as behavior. So it's also the behavior that you are showing, the tone, your example. If you pay lip service to the law and to King 4, if your tone shows that, if your behavior shows it, believe me, you will influence as a leader a culture that will also just pay lip service to it. I refer again to Owen's example of Enron. So it's to me, and here my thinking goes along the lines of Ken Wilber's integral theory. For good governance to be in place, you have to have the right individual belief systems. You have to have the right, an appropriate and suitable collective belief system, which is your culture. You have to have the right rules, yes. And then you have to have the right behaviors, how you engage with that rules, how you influence culture. All of that makes up the ingredients that bakes the governance cake. If you don't have the right rules, there's a problem. If the individual belief systems are not in line with those rules, you have a problem. You have a Sanral situation where you have the rule for paying toll fees, it's law, but many of us flout it. I wonder how many of us in this meeting today pay our toll fees. Just say no, we believe that rule is wrong, so we don't do it, and so on. So I get back to my point, and I'll conclude now, is that we need to think in an integrated way. You can't just take any one of these components. Yes, sometimes nomination committees fail. But nominations committees are influenced by the culture, by the individual beliefs of the people who sit on those, by the accountability system, and so on. We need to see that big picture. It's not one thing. If we latch onto one thing, we're never going to resolve the corporate governance challenge that we're facing. We need to look at it as holistically and address it holistically. It's not one thing. It's a collection of things.
Can this ecosystem, all of the ingredients, and I love the example that you use, the analogy of the ingredients of the cake, because you know you've baked one cake and you understand that every single thing of it, every time, etc., is crucially important to a great outcome. Can it operate in a climate that is full of stressors? If we look at the PPE and the infrastructure spend over the past few months, that's, you know, money in, money out, no accountability. Over the past few years, corporate failures, Tongaat, EOH, etc., etc. The list goes on and on and on. And one of the questions in the Q&A box is, corporate failures seem to increase. There seems to be more now with King 4 than with King 3, or is it just because of media attention? So the awareness of corporate governance, the awareness of corporate failures, it's on the increase, and so is the difficult and the tough economic climate. And now I'm going to ask a controversial question, and I pose it to you because I know you've got opinions on this. Isn't it then time for something different? Isn't it time to say, for instance, hypothetically, and I've got no inside information whatsoever, public disclosure, if King 5 was in the works, is it not the time to legislate King 5 to fill those gaps? Companies Act bones, let's legislate the flesh then, as Ansie called it. Is it not time for that? Because we're living in an economic climate where the behavior patterns are changed. So you've got behavior patterns when they're put under stress in a tough economic climate, they are being changed. Choices based on influence, and those influences change due to the economic climate. Is it not time for something completely different? And what would that completely different look like if we want to get out between this rock and rotten place? So less of a focus on what is the prevention and more of a focus on what causes corporate failures, which we've touched on, tone at the top, people with ill intent, etc., and more towards the cure side. If we were then to make the next 10, 15 minutes focused on the cure, what would that look like? And this is just purely in a dream-based world.
Juanita, you can't legislate this. It's simply impossible. You can't legislate that Cricket South Africa must go and win cricket matches. You can't do that. So the King Committee has said that the tick box quantitative governance doesn't work. It had unintended consequences. Bratton speaks about the ex post and the ex ante. Like, we're always wise in hindsight. As Warren Buffett says, it's always easier to look through the rearview mirror than it is to look through the windscreen. So, and what we find is that if you are what they refer to as a predator fraudster, and you're somebody who doesn't have integrity, but you're smart, and you see the chinks and the weaknesses in these systems, you find a way to circumvent them. In fact, you may even take great delight in doing that. And the fact that you end up possibly going to jail one day for your life and forking out R1 million doesn't seem to deter these people. So we have very strict laws in South Africa. But when you have collusion, so it's the so-called ABC, the bad apple, the bad bushel, and the bad crop. A fantastic academic, I really love his work, a guy called Michael Murthy-Krishna at the London School of Economics. He does these games, and basically the one point that's made is that bribery and corruption is to some extent encoded into our DNA. And part of this is because of the evolution of human beings. The environment is tough out there, and sometimes we have to kind of band and work together in order to preserve ourselves. And we see it play itself out in society at societal level, country level, group level, and individual level. what he does when he introduces bribery and you get free riders, the system very quickly breaks down. But there is a message of hope in all of this. He says we have to build strong institutions. Now in South Africa, it was inevitable that Eskom was going to collapse one day. And it doesn't matter how much you want to smoke screen it. It was inevitable that SAA were going to collapse. You've seen the challenge of trying to get the former chair declared a delinquent director. That's not King Committee. That's going through the courts. And generally what we find is that these directors have very deep pockets. And often it's from their ill-gotten gains that they're very happy to pay the best lawyers. Now, I recall a tweet once. Somebody is a very active tweeter. And she said that it's reprehensible that these advocates and attorneys should actually go and defend these people. The point is, you can't tell an advocate no, because in South Africa, I think we have the equivalent of, as the cab jumps past, as an advocate, you're obliged to defend that person. And heaven forbid the day that we compromise our rule of law. Advocate Madonsela, she's very, she says the rule of law is sacrosanct. So we need to get back to that. And we need to make sure that our institutions are strengthened, that our National Prosecuting Authority has competent prosecutors, that shareholders know that there are remedies available to them. As that a board member, we duty bound that when people come to AGM and ask you questions, you don't just fob them off. That we create a body of shareholder activists, as I said, that don't go and just ask about financial returns. And that at the end of the day, I honestly believe that we can. But there have been cases where companies have tried to focus on values alone. In other words, there's a very famous corporate scandal in the US where they said, we're just going to go according to ethics and values, and we're going to only employ people who do that. There's a very famous consulting company. It's a household name. It failed. You've got companies that are solely rules-based. They also fail. So what we need to do is we had to have a mix of values and rules. And somehow we have to navigate them, the dilemma between performance and conformance. You end up running the risk that if you clamp down and you make it that shareholders have more rights in terms of limiting the unlimited liability, limited liability, if suddenly shareholders are having to cough up for the company's debts, you're going to have no shareholders. If you send directors to jail for years and years, then they're going to get the best lawyers to defend them. And this is a societal problem. It's the ecosystem. But there are mechanisms for us to do better at this. And I just want to conclude by saying, and I think one should avoid trying to make Mervyn King a cult figure, but we must acknowledge that this is a global person now. Sometimes I think that Mervyn King gets more recognition abroad than he does in South Africa. We have a doyen of corporate governance here. We need to listen more perhaps to what he's saying. But recently, and one thing that Prof King has been advocating strongly for is the merging of standards. So in the last week, it's fantastic news to hear that there's going to be a new comprehensive corporate reporting regime. We've got the CDB, the CBSB, the GRI, the IRC, and the SASB coming together to say, we need to have a common standard. Now, South Africa is a global player. So if you look at the G20 principles and you go and look at corrupt practices, there's 17 things there. Nothing at there is at odds with the King Code. And they even talk about SMEs. So you might find that you want to trade internationally. If you're not in line with what the G20 is saying in terms of corruption, you may find that your avenues to international trade are closed off. The King Committee looks around the world and sees, how do we fit. But we in South Africa made the decision that we go for the stakeholder inclusive approach, which is different to the UK, which is the shareholder enlightened approach. We're different to the US, which is the rules-based approach. And I think that we need to understand that a lot better. Lastly, I've called often that all directors of listed companies and state-owned enterprise, in my view, should at least be a certified director and at best a chartered director. Put your money where your mouth is, sit in class, discuss these things. You don't have to always discuss them in the boardroom. Continuing professional development, read the case law, understand what it means to set up, have delighted customers, employees who come to work every day because they're excited and proud to work for the company. Let's put South Africa first. I think we can make a difference and make the change.
Thanks very much, Owen. Ansie, your concluding statements?
I'll carry on where Owen has left it off. Corporate governance is often misunderstood, I think, as an intuition, as common sense, and you add a couple of rules to it, just like, and often even, like I said, something that you understand secondhand. Corporate governance is both art and science. Corporate governance is about judgment, it's about wisdom. It's not, if it was as easy as just applying a couple of rules, then we may as well have robots, program robots with an algorithm and have them be the directors of our companies. The reason why we don't have robots with program algorithms is because governance is not a formula. Governance is both science, but it's also an art. It's that wisdom aspect that must come into it, that experiential aspect, that ethical aspect. I just want to supplement what Owen has said, get back to the definition of corporate governance. Corporate governance is about ethical and effective leadership. In other words, leadership that leads to performance, to results, but that is also ethical. You need both these legs. It's not, you can easily gloss over that definition and think, heard this before. It's very intentional that we use those words. Ethical and effective leadership. You need both those components. And then just getting back to the ingredients, it starts with us as individuals. What we believe, the tone that we set, our behavior, before it can filter into the collective. We all think, there's this famous ethics experiment that presenters on ethics are fond of using, is that they would ask the audience, how much of the audience members considered themselves as generally ethical people, and then almost all of the hands will go up. And then they would say, okay, so how are your family members ethical? And then some of the hands will go down. And then are the people in your workplace ethical? And then more of the hands. And the bigger that circle goes, the more hands go down. But it's completely illogical, because how can we say that we are all ethical as individuals, but we live in a country that's unethical? That means that the country, the citizenship of this country is made up of individuals. You can't have ethical individuals that make up an unethical country. So it starts with us, I believe, and with each of us taking responsibility for our own ethics, for how we show up, and then to influence our environments and to do what we can to make sure that the right thing happens in the right way, in an effective way that leads to results where we operate and where we have influence. That's our task as leaders, to exercise that influence so that we can change our environment.
Final question then from the Q&A box. Do non-profit organizations, charity organizations, church-based organizations, municipal organizations, government service organizations, public sector, do they get a free pass? Is the Companies Act and relevant legislation, PFMA, MFMA, etc., and King 4, is it only for JSE listed companies? Or does it apply, should it apply, can it apply across the board? Owen?
Oh, Juanita, so I think this is an example of the King Committee, excuse me, listening, because we no longer, we don't talk about King 3, King 1, King 2, King 3 spoke about companies. King 4 talks about governing bodies. It's designed to have universal applicability. There's also this important concept of proportionality, because I think one understands that if you're a listed company, you've got the resources to do really everything that's recommended. But if you're a church or an NGO, so proportionality says that you should apply your mind and see, those things. So to go out and have an audit committee and a nominations committee for a small NPO is clearly beyond the reasonable expectations. So it's really about understanding the essence of what proportionality says. So no, there's no free pass, but it's not mandatory for them either. Rhodes University, for example, our council says that we will apply and explain King 4. One of the things in the previous statute, it said that the vice chancellor is the member of all committees, but you took the guidance from the King committee that says that the audit committee must be independent people, for example. So you can see how it influences, and it's influenced the statute now. But we can't do everything that King, so proportionality, apply and explain. What I wanted to just conclude on those, that and Ansie made reference to the ethical, Stanford prison experiment, Philip Zimbardo with and the Lucifer effect. Why good people do bad things? Again, it's very complex, but the corporate sins of sloth, greed, generally you'll find that when greed comes in, slothfulness, you're not reading the board pack, you're not applying your mind, has to be counterbalanced by the kind of virtues. And one of those is courage. And directors have to deal with conflicts of interest every time they think about their organization. And it doesn't mean that just because everybody else is doing. Lance Armstrong, he said, I never doped because everybody else was doping. Just because everybody else is doing it doesn't mean that we must do that too. But of course, it takes tremendous courage to do that. Whistleblowing needs to be sorted out in South Africa. As Professor Mervyn King pointed out the other day, whistleblowers, it's dealt with in many different places. Maybe the time has come to have an act that deals specifically with whistleblowing and how you protect whistleblowers. Because what we know is that if you whistleblow, you're likely to lose your job. You could even lose your life. Tremendous courage. Everybody hates a snitch. That's the counterbalance. You seem to be a snitch. Nobody likes a snitch, but whistleblowers are very important when they uncover these things. We need to protect them, because the system is not perhaps working properly. And then lastly, in relation to the integrated thinking and stakeholder engagement and the functioning of social and ethics committees, and I personally would like to see strong directors on social and ethics committee, because the Companies Act says that if you're a member of the social and ethics committee, you can ask any employee, any director to come and explain yourself. The counterpoint is that people say it paralyzes things. If the social and ethics committee, then there's a business decision to be made. Now, do we need to wait for them to do that? We're in a fast-moving society. We've got to take advantage of these things. So that's where social and ethics committee should really have the strong independent directors, perhaps. So that's just my concluding thought. Some suggestions as to how we could do things differently and better.
Thank you very much, Owen. Ansie, to you, do non-profit organizations, public sector organizations, smaller organizations get a free pass?
No, absolutely not. You're dealing with other people's interests. People entrust their donations to you, a non-financial interest like the beneficiaries trust for you to deliver. Corporate governance is part and parcel of every corporate entity. Doesn't matter how, the manner of incorporation does not matter. What will make a difference is that the governance system that you implement will look different in a non-profit organization than it would look in a listed company, because a listed company has different risks associated with it than a non-profit company, and different challenges that you need to address in a different way. So no, in fact, the Companies Act has a special schedule just for non-profit organizations. King has a specific schedule supplement that deals with non-profit organizations. No, if you operate in a corporate form, corporate governance is applicable.
Thank you very much, Ansie. Vikeshni, if you can run the audience poll for us, please, as we conclude the session. Ladies and gentlemen, I'd like to see your thoughts, please, on where the fault lies. And it would be interesting to see if it's changed at all. few more seconds. And 5, 4, 3, 2, 1. The number 1 is still the board, the directors. Number 2, CEO and executive management. It will be interesting to see, I cannot remember all of the stats from the first one, it will be interesting to see how this has changed, if at all, during the discussion. My conclusion for this, ladies and gentlemen, before I hand back over to Vikeshni for closing comments and closing announcements, is to answer the question, where does the fault lie, seems to be impossible, and if not impossible, incredibly complex. There seems to be a lot of cause and a lot of reason for cause. There seems to be a lot of things in place for the prevention. But if we are to find a cure for this persistent corporate governance failures, from what I've taken from Owen and Ansie, and thank you very much for your participation, is that each player in this ecosystem of corporate governance needs to sign up for understanding both the art and the science of corporate governance, so that they're in a really good position to help direct, whether from a shareholder point of view, with their voting rights, or from a director point of view, to sign up for running companies and directing companies, both public and private, both profit and non-profit, that can generate a profit without doing harm. Ladies and gentlemen, thank you so very much for your participation. I know there are quite a few questions in the Q&A session that we didn't get to. The IoD team is recording all of them and will group some of those into pertinent discussions that you might just see in the future Boardroom Bytes at 9 discussions. Vikeshni, over to you.
Thank you, Juanita, Ansie, and Owen. Yes, there is a lot of questions in our Q&A box, Juanita. So I've actually was discussing in the background, we will look at a way in which we produce an FAQ or some sort of thought leadership so that we can actually address all of the questions that we were raised in a written format as well. So we will look at how we address, all comments that were actually raised. So not to fear, as well as the fact that this session is recorded, and the recording of the session will be made available on our website. It will be shared to everyone that has attended this morning via email, and you're more than welcome to share this with the rest of your peers and on social media as well. So this recording will be available as well. From my side, it's really just wanting to say a huge thank you to yourself, Juanita, for facilitating this session. I know the audience were not able to see the questions that were being raised as it was just coming on our side, but I can assure you that Juanita did ensure that whatever topics or areas that were addressed, she did bring that all in within her questioning. So she did address the areas that were raised in the Q&A. And thank you to Ansie and Owen for giving us your time and sharing your views and opinions on the matter. From the feedback that I've been seeing in the chat group with attendees posting to us as the panelists, everyone has enjoyed the session. They found this quite thought-provoking, and it looks like it's a takeaway of a lot of things to think about, and also how we go about applying best corporate governance within our own organizations as well, and how we look at it. So thank you very much. Everyone's contact details via LinkedIn is on this page as well. You will get the slides as well in the email that will follow later on in the week. So you can also contact the panelists directly if you want to discuss anything with them or get in touch. So thank you, everybody, and I look forward to seeing all of you again next week. And out of interest from your poll sessions, the board of directors were previously 74%, so that went down slightly lower. Shareholders went up by quite a bit. Your CEO and executive management went down by 10%, but relatively the same. Application and implementation actually of ACT and King 4 went up. So that was some of the changes in the polling.
That is very interesting. Vicky, thank you so very much from my side. Thank you very much, everybody. Goodbye.
Bye.